Yeah, evening time, and sir, people will be coming from offices. I think seriously.
That could be an issue. Okay, no issues. So I
Yes.
mean, all of you as course, you can keep on adding people. So very good evening, all the participants. Today, let us discuss some of the newly introduced acts. Let me share my screen also with you. So first of all, let us do this DPDP Act, Data Protection and Data Privacy. Let us see what is this act. I hope my screen is visible. Is it visible? My screen is visible or not?
Visible, sir. Yes, sir.
Yes,
Now
sir.
it has come
Okay.
now. Visible, sir.
Okay. So the first point, you have to tell me whether this act has been notified or not. This is the first thing.
Notified, sir.
No.
Acha.
Act has been notified, but rules and regulations are not there.
Okay.
Something similar to individual insolvency. So, no application can be filed.
Okay.
This is the first important thing you have to remember. No rules have come. Only act is there. No rules and regulations. Because unless rules comes, there is no format to file an application under this DPDP Act. Okay. This is the first important thing you have to remember. Now, first things first. So what is the context? So personal data is information that relates to an identified or identifiable individual. Businesses as well as government entities process personal data for delivery of goods and services. Processing of personal data allows understanding preferences of individuals, which may be useful for customization, targeted advertising, and developing recommendations. Processing of personal data may also aid law enforcement, but unchecked processing may have adverse implications for the privacy of individuals, which has been recognized as a fundamental right. So this is the case, Justice K.S. Puttaswamy, retired versus Union of India, Supreme Court of India. So they said it may subject individuals to harm such as financial loss, loss of reputation and profiling. So you cannot make indiscriminate use of personal data. So this is what this law aims at. Now let us understand the chronology of events. I think I have recorded, yes. So till recently, India did not have a standalone law on data protection. Use of personal data was regulated, first of all, under Information Technology Act. Then a joint committee was formed. So that joint committee gave a report on the Personal Data Protection Act 2019 in December 2021. In 2017, the central government constituted a committee of experts on data protection, chaired by Justice B.N. Sri Krishna, to examine issues relating to data protection in the country. So, this committee submitted its report in July 2018. A free and fair digital economy, protecting privacy, empowering Indians. So, committee of experts under the chairmanship of Justice B.N. Sri Krishna, July 18. So based on the recommendations of the committee, the Personal Data Protection Act 2019 was introduced in Lok Sabha in December 2019. So Personal Data Protection Act 2019 as introduced in Lok Sabha. The act was referred to as JPC, which submitted its report in December 2021. In August 2022, the act was withdrawn from Parliament. In November 2022, a draft act was released for public consultation. Now this draft Digital Personal Data Protection Act. So Ministry of Electronics and Information Technology, November 18, 2022. In August 2023, the Digital Personal Data Protection Act was introduced in Parliament. The Digital Personal Data Protection Act 2019 as introduced in Lok Sabha. And then this Digital Personal Data Protection Act 2023, it was passed by Parliament. So this is the chronology of events. Now, let us see the key features of this data. Applicability. So this act applies to the processing of digital personal data within India, where such data is collected online or collected offline and is digitized. It will also apply to the processing of personal data outside India if it is for offering goods or services in India. Personal data is defined as any data about an individual who is identifiable by or in relation to such data. Processing has been defined as wholly or partially automated operation or set of operations performed on digital personal data. It includes collection, storage, use, and sharing. So these are the definitions. This act will apply to the processing of digital personal data within India where such data is collected online or collected offline and is digitized. It will also apply to such processing outside India if it is for offering goods or services in India. Okay? So this personal data may be processed only for a lawful purpose upon consent of an individual. Consent may not be required for specified legitimate uses such as voluntary sharing of data by the individual or processing by the state for permits, licenses, benefits and services. So data fiduciaries. So data fiduciary is also an important concept which we will see. So data fiduciaries will be obligated to maintain the accuracy of data, keep data secure and delete data once its purpose has been met. The Act grants certain rights to individuals, including the right to obtain information, seek correction and erasure, and grievance redressal. The central government may exempt government agencies from the application of provisions of the Act in the interest of specified grounds such as security of the state, public order, and prevention of offences. The central government will establish the Data Protection Board of India to adjudicate on non-compliance with the provisions of the Act. Now the key issues and analysis. Exemptions to data processing by the state on grounds such as national security may lead to data collection, processing and retention beyond what is necessary. So this may violate the fundamental right to privacy. The Act does not regulate risks of harms arising from processing of personal data. The Act does not grant the right to data portability and the right to be forgotten to the data principle. The Act allows transfer of personal data outside India except to countries notified by the central government. This mechanism may not ensure adequate evaluation of data protection standards in the countries where transfer of personal data is allowed. Now, this Data Protection Board of India. The central government will establish the Data Protection Board of India, and key functions of the board include monitoring compliance and imposing penalties, directing data fiduciaries to take necessary measures in the event of a data breach, and hearing grievances made by affected persons. Board members will be appointed for 2 years and will be eligible for reappointment. The central government will prescribe details such as the number of members of the board and the selection process. Appeals against the decisions of the board will lie with TDSAT. So this is appellate tribunal. Okay. Penalties. The schedule to the Act specifies penalties for various offences such as up to 200 crores for non-fulfillment of obligations for children and rupees 250 crore for failure to take security measures to prevent data breaches. Penalties will be imposed by the board after conducting an inquiry. Now let us see Part B. So Part B contains the key issues and analysis. Exemptions to the state may have adverse implications for privacy. Because state has been given several exemptions under the Act. So personal data processing by the state has been given several exemptions under the Act. As per Article 12 of the Constitution, the state includes central government and state government, local bodies, authorities and companies set up by the government. So there may be certain issues with such exemptions. The Act may enable unchecked data processing by the state, which may violate the right to privacy. So Supreme Court has held that any infringement of the right to privacy should be proportionate to the need for such interference. Exemptions for the state may lead to data collection, processing and retention beyond what is necessary. This may not be proportionate and may violate the fundamental right to privacy. The Act empowers the central government to exempt processing by government agencies from any or all provisions in the interest of aims such as the security of the state and maintenance of public order. None of the right of data principles and obligations of data fiduciaries except data security will apply in certain cases such as processing for prevention, investigation and prosecution of offences. The Act does not require government agencies to delete personal data. Another point is regarding the consent. Personal data may be processed only for a lawful purpose after obtaining the consent of the individual. A notice must be given before seeking consent. The notice should contain details about the personal data to be collected and the purpose of processing. Consent may be withdrawn at any point of time. Consent will not be required for legitimate uses, including specified purpose for which data has been provided by an individual voluntarily, provision of benefit or service by the government, medical emergency, and employment. For individuals below 18 years of age, consent will be provided by the parent or the legal guardian. Now, there are certain rights and duties of the data principal. An individual whose data is being processed, that is called the data principal, will have the right to obtain information about processing, seek correction and erasure of personal data, nominate another person to exercise rights in the event of death or incapacity, and grievance redressal. Data principals will have certain duties. They must not register a false or frivolous complaint and furnish any false particulars or impersonate another person in specified cases. So violation of duties will be punishable with a penalty of up to rupees 10,000. Next is obligations of data fiduciaries. The entity determining the purpose and means of processing data fiduciary must make reasonable efforts to ensure the accuracy and completeness of data, build reasonable security safeguards to prevent a data breach, inform the Data Protection Board of India and affected persons in the event of a breach, and erase personal data as soon as the purpose has been met and retention is not necessary for legal purposes. In case of government entities, storage limitation and the right of the data principal to erasure will not apply. Now, transfer of personal data outside India. The Act allows transfer of personal data outside India except to countries restricted by the central government through notification. Transfer of personal data outside India. The Act allows transfer of personal data outside India except to countries restricted by the central government through notification. Now, exemptions. Right of the data principal and obligations of the data fiduciaries except data security will not apply in specified cases. So what are these specified cases? These include prevention and investigation of offences and enforcement of legal rights or claims. The central government may by notification exempt certain activities from the application of the Act. These include processing by government entities in the interest of the security of the state and public order, and research, archiving or statistical purposes. After the purpose for processing has been met. Using the above exemptions, on the ground of national security, a government agency may collect data about citizens to create a 360-degree profile for surveillance. It may utilize data retained by various government agencies for this purpose. This raises the question whether these exemptions will meet the proportionality test. Because Supreme Court has already held that the data can be used only in proportion. For interception of communication on grounds such as national security, the Supreme Court had mandated various safeguards, including establishing necessity. Because normally communication cannot be intercepted. But if the government wants to intercept the communication, say call recording or something of that sort. So for interception of communication on grounds such as national security, the Supreme Court had mandated various safeguards, including establishing necessity, purpose limitation, and storage limitation. Okay. Rule 419A of the Indian Telegraph Rules, issued under Section 7(2) of the Indian Telegraph Act, and People's Union for Civil Liberties versus Union of India, Supreme Court of India, December 18, 1996. So these are similar to the obligations of data fiduciaries under the Act. the application of which has been exempted. The Sri Krishna Committee had recommended that in case of processing on grounds such as national security and prevention and prosecution of offences, obligations other than fair and reasonable processing and security safeguards should not apply. It observed that obligations such as storage limitation and purpose specification, if applicable, would be implemented through a separate law. So India doesn't have any such legal framework. In the United Kingdom, the data protection law, which was enacted in 2018, provides similar exemptions for national security and defense. However, actions such as bulk processing of personal data sets by government agencies for intelligence and law enforcement activities are regulated under the Investigating Powers Act. Now, whether overriding consent for purposes such as benefit, subsidy, license, and certificate is appropriate, because it says that consent may not be required in these cases. So the Act overrides consent of an individual where the state processes personal data for provision of benefit, service, license, permit, or certificate. It specifically allows use of data processed for one of these purposes for another. It also allows use of personal data already available with the state for any of these purposes. Hence, it removes purpose limitation, which is one of the key principles for protection of privacy. Purpose limitation means data should be collected for specific purposes and should be used only for that purpose. So the question is whether such exemptions are appropriate. Since data taken for various purposes could be combined, this could allow profiling of citizens. So on the other hand, if consent were required, individuals would have the autonomy and control over collection and sharing of their personal data. The Act does not regulate harm arising from processing of personal data. The Act does not regulate risks of harms arising out of processing of personal data. The Sri Krishna Committee had observed that harm is a possible consequence of personal data processing. Harm may include material losses such as financial loss and loss of access to benefits or services. It may also include identity theft, loss of reputation, discrimination, and unreasonable surveillance and profiling. It had recommended that harms should be regulated under the data protection law. The Personal Data Protection Act 2019 had defined harm to include mental injury, identity theft, financial loss, reputational loss, discriminatory treatment, and observation or surveillance not reasonably expected by the data principle. The 2019 Act required data fiduciaries to take measures to prevent, minimize, and mitigate risks of harms. Now, right to data portability and the right to be forgotten not provided. The Act does not provide for the right to data portability and the right to be forgotten. Okay? The 2018 draft and the 2019 Act introduced in Parliament provided for these rights. Okay? Rights to data portability. What is this right to data portability? The right to data portability allows data principals to obtain and transfer their data from data fiduciary for their own use in a structured, commonly used and machine-readable format. It gives the data principal greater control over their data. It may facilitate the migration of data from one data fiduciary to another. One possible concern has been that it may reveal trade secrets of the data fiduciary. The Sri Krishna Committee had recommended that to the extent it is possible to provide the information without revealing such trade secrets, the right must be guaranteed. The Joint Parliamentary Committee had observed that trade secrets cannot be a ground to deny the right data portability, and it may only be denied on the ground of technical feasibility. Next is right to be forgotten. The right to be forgotten refers to the right of individuals to limit the disclosure of their personal data on the internet. The Sri Krishna Committee observed that the right to be forgotten is an idea that attempts to instill the limitations of memory into an otherwise limitless digital sphere. However, the committee also highlighted that this right may need to be balanced with competing rights and interests. Exercise of this right may interfere with someone else's right to free speech and expression and the right to receive information. Its applicability may be decided on factors such as the sensitivity of the personal data to be restricted, the relevance of the personal data to the public, and the role of the data principle in public life. Now, adequacy of protection in case of cross-border transfer of data. The Act provides that the central government may restrict the transfer of personal data to certain countries through a notification. This implies the transfer of personal data to all other countries without any explicit restrictions. So this question is whether this mechanism will provide adequate protection. The aim of the regulation of transfer of personal data outside India is to safeguard the privacy of Indian citizens. In the absence of robust data protection laws in another country, data stored there may be more vulnerable to breaches or unauthorized sharing with foreign governments as well as private entities. Okay. Now they are making a comparison. What the 2019 Act which was repealed and what is this 2020 Act. So it says the 2019 Act required that for certain categories of data, transfer to a country should be allowed only if it provides for adequate level of protection. Okay. But the 2022 draft took a different approach, with the central government notifying countries where any personal data may be transferred. Okay. The draft Digital Personal Data Protection Act 2022, Ministry of Electronics and Information Technology. So both these mechanisms require a case-by-case evaluation. Now, shorter appointment term may impact independence of the board. The Act provides that members of the Data Protection Board of India will function as an independent body. Members will be appointed for 2 years and will be eligible for reappointment. A short term with the scope for reappointment may affect independent functioning of the board. Now let us see what are the key functions of the board. So key functions of the board are monitoring compliance, carrying out investigations, and adjudging penalties. In case of tribunal, the Supreme Court had observed that short term, along with the provisions of reappointment, increases influence and control of the executive. Okay. So they say the term is too short. Additional provision for children. So additional obligations apply to processing data of children. Okay. Now let us say this. Definition of child is different from other jurisdictions. So while it is an accepted principle that the processing of a child's data should be subject to greater protection, there are differences in how different jurisdictions define a child for giving consent for the processing of personal data. Under the Act, a child has been defined as a person below 18 years of age. In USA and UK, persons above the age of 13 can give consent for the processing of personal data. Okay. So the Sri Krishna committee had recommended that while determining the age of consent of children, certain factors should be considered. These include minimum age of 13 and maximum age of 18 and a single threshold for ensuring practical implementation. It also observed that 18 years may be too high from the perspective of the full autonomous development of a child. However, to be consistent with the existing legal framework, the age of consent should be 18 years. Under the Indian Contract Act, the minimum age to sign a contract is 18 years. Now, taking verifiable parental consent may require verification of everyone's age on digital platform. So the Act requires all data fiduciaries to obtain verifiable consent from the legal guardian before processing the personal data of a child. To comply with this provision, every data fiduciary will have to verify the age of everyone signing up for its services. It will be needed to determine whether the person is a child and thereby obtain consent from their legal guardian. This may help avoid instances of children giving false declaration. However, this may reduce anonymity in the digital sphere. Then lack of clarity on what constitutes detrimental to well-being of a child. So the Act provides that data fiduciary will not undertake any processing which has detrimental effect on well-being of children. The Act has not defined detrimental effect. It has also not provided any guidelines for determining such effect. Now, exemption from notice for consent may not be appropriate. So the Act empowers the central government to notify certain data fiduciaries or classes of data fiduciaries, including startups, from certain obligations. This has to be done with due regard to the volume and nature of personal data. One of the obligations which may be exempted is notice for consent. The requirement to seek free and informed consent will continue to apply in case of these entities. However, if there is no obligation to provide notice regarding nature of data collected and purpose of processing, it may be argued that the data principal will not be able to provide informed consent. Okay. Now let us see the key differences between various drafts of the data protection law. So this is a table which we have prepared comparing the various drafts of the data protection law. Because the variations will help you understand ki, what is the tinkering done. This is the act actually, the Digital Personal Data Protection Act. Let us see some of the important definitions here. First definition is data fiduciary. Now, what is data fiduciary? Data fiduciary means any person who alone or in conjunction with other person determines the purpose and means of processing of personal data. वो data fiduciary. Data principal कौन है? Data principal means the individual to whom the personal data relates. And where such individual is child, includes the parent or lawful guardian of such a child. A person with disability includes a lawful guardian acting on her behalf. Data processor कौन है? Data processor means any person who processes personal data on behalf of a data fiduciary. और डेटा प्रोटेक्शन ऑफिसर कौन है? डेटा प्रोटेक्शन ऑफिसर मीन्स एन इंडिविजुअल अपॉइंटेड बाय द सिग्निफिकेंट डेटा फिड्यूशियरी अंडर क्लॉज ए ऑफ सबसेक्शन 2 ऑफ सेक्शन 10. Processing. Processing is very important definition. So processing in relation to personal data means a wholly or partly automated operation or set of operations performed on digital personal data and includes operations such as collection, recording, organization, structuring, storage, adaptation, retrieval, use, alignment or combination, indexing, sharing, disclosure by transmission, dissemination, or otherwise making available, restriction, erasure, or destruction. Now, significant data fiduciary. Significant data fiduciary means any data fiduciary or class of data fiduciaries as may be notified by the central government. Okay? Under section 10. Illustration. Let us understand it by way of an illustration. So it says, X is an individual while blogging her views has publicly made available her personal data on social media. Okay? In such cases, the provisions of this act shall not apply because she herself has given her personal data on social media. Obligations of data fiduciary. Let us understand it by way of illustration. X is an individual. He opens a bank account using the mobile app or website of Y, a bank. To complete the Know Your Customer requirements under law for the opening of bank account, X opts for processing of her personal data by Y in a live video-based customer identification process. Y shall accompany or precede the request for the personal data with the notice to X describing the personal data and the purpose of its processing. X is an individual, gave her consent to the processing of her personal data for an online shopping app or website operated by Y, an e-commerce service provider, before the commencement of this act. Upon commencement of the act, Y, as soon as practicable, give through email, in-app notification or other effective method information to X describing the personal data and the purpose of its process. ठीक है, ये हर एक क्लॉज एक्सप्लेन की है, उसके बाद में इलस्ट्रेशन दे रखी है. X is an individual, he downloads by a telemedicine app. आजकल क्या है, बहुत सारी चीजें ऐप पर ही चल रही हैं, है ना. ऐप पर आपका डेटा तो वो लेते ही है. So Y requires the consent of X for the processing of her personal data for making available telemedicine services. भाई उसको पूछेगा ना वो कि आपको क्या बीमारी है, ये सब चीजें. And accessing her mobile phone contact list. And X signifies her consent to both. ठीक है. Since phone contact list is not necessary for making available telemedicine services, her consent shall be limited to the processing of her personal data for making available telemedicine services. ठीक है भाई, टेलीमेडिसिन सर्विसेज के लिए उसका पर्सनल डेटा तो ठीक है, लेकिन मोबाइल कॉन्टैक्ट्स की जरूरत थोड़ी है. X is an individual, he buys an insurance policy using the mobile app or website of Y, an insurer. ठीक है. She gives to Y her consent for processing of her personal data by Y for the purpose of issuing the policy and waiving her right to file a complaint to the Data Protection Board of India. ठीक है. So part 2 of the consent relating to waiver of a right to file a complaint shall be invalid. ठीक है. X is an individual, he is the user of an online shopping app or website operated by an e-commerce operator service provider. ठीक है. X consents to the processing of her personal data by Y for the purpose of fulfilling her supply order and places an order for supply of a good while making payment for the same. Now, if X withdraws her consent, Y may stop enabling X to use the app or website for placing orders, but may not stop the processing for supply of the goods already ordered and paid for by X. X is a telecom service provider. He enters into a contract with Y data processor for emailing telephone bills to the customers of X. ठीक. Z is a customer of X who had earlier given her consent to X for the processing of her personal data for emailing of bills. Downloads the mobile app of X and opts to receive bills only on the app. X shall itself seize and shall cause Y to seize the processing of the personal data of Z for emailing bills. X is an individual. He makes a purchase at Y, a pharmacy. She voluntarily provides Y her personal data and requests Y to acknowledge receipt of the payment made for the purchase by sending a message to her mobile phone. So Y may process the personal data of X for the purpose of sending the receipt. X is an individual. He electronically messages Y, a real estate broker, requesting Y to help identify a suitable rented accommodation for her and shares her personal data for this purpose. ठीक है. Y may process her personal data to identify and intimate to her the details of accommodation available on rent. Subsequently, X informs Y that X is no longer needs help from Y. So Y shall cease to process the personal data of X. X is a pregnant woman, enrolls herself on an app or website to avail of government's maternity benefits program, while consenting to provide her personal data for the purpose of availing of such benefits. Government may process the personal data of X, processing to determine her eligibility to receive any other prescribed benefit from the government. X is an individual registers herself on an online marketplace operated by Y, an e-commerce service provider. X gives her consent to Y for the processing of her personal data for selling her used car. The online marketplace helps conclude the sale, so Y shall no longer retain her personal data. If the purpose is served, then the data cannot be used. X is an individual, decides to close her savings account with Y, a bank. Y is required by law applicable to banks to maintain the record of the identity of its clients for a period of 10 years beyond closing of the accounts. ठीक है. So since retention is necessary for compliance with law, Y shall retain X's personal data for the said period. ठीक. X is an individual. ये कुछ special provisions. So X is an individual. He takes a loan from Y, a bank. X defaults in paying her monthly loan repayment installment on the date on which it falls due. Y may process the personal data of X for ascertaining her financial information, assets and liabilities. Now, who would be impacted? Educational institutions, utility companies, because these are the institutions which are maintaining data. And financial institutions, service providers, even CA firms, real estate sector, aviation and transportation sector, hospitals, hospitality and tourism sector, online subscriptions and many more. So these will be impacted by DPDP Act. New compliances and processes arising from Digital Personal Data Protection Act. First of all, data privacy checklist for your organization. Then specific purpose identified and communicated. Data processing records and manner well defined. Data minimization, data storage, data protection clauses intact in contracts. Digital policy formulated for your organization. Data protection aligned with vendors. Data protection aligned with buyers. Data protection assessed and channelized for the manpower in your organization. And data processing consent notice in place. So these are the things. These are the compliances which you should take note of. ठीक है जी. तो ये था इसके ऊपर थोड़ा सा डिजिटल डेटा प्रोटेक्शन एक्ट. अब थोड़ा सा कॉन्स्टिट्यूशन के ऊपर देख लेते हैं. I hope now my screen is visible. No?
Yes, sir.
So what it says, first of all, the most important thing in constitution is writs. So part 3 of the constitution provides for legal remedies for the protection of these rights against their violation by the state or other institutions or individuals. It entitles the citizens of India to move the Supreme Court or High Courts for the enforcement of these rights. The state is forbidden from making any law that may conflict with the fundamental rights. These rights are mentioned under Articles 12 to 35 of the Indian Constitution. These are predefined punishments in case of violation of these rights upon the discretion of the judiciary. ठीक है. Now, what is a writ? And what is a writ petition? Writ is different. Writ petition is different. So writs are written orders issued by the Supreme Court to provide constitutional remedies to protect the fundamental rights of citizens from a violation. Okay. So Article 32 also empowers Parliament to authorize any other court to issue these writs. And Article 226 empowers all the High Courts of India to issue the writs. Okay. So writs of India, they are borrowed from English law, where they are known as prerogative writs. Now, what is a writ petition? Writ petition is essentially a court petition for extraordinary review, asking a court to intervene in a lower court's decision. एक मिनट जरा आप डिस्कस कीजिए. मैं ना पानी पी रहा हूँ जरा, मुझे प्यास लग रही है बड़ी तेज.
I think that is sufficient.
Okay, so let us continue. Now, what is a writ petition?
I'll read, sir. आप
हाँ पढ़िए 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 please.
ठीक है, sir. Yeah.
हाँ जी.
What is a writ petition? A writ petition is essentially a court petition for extraordinary review asking a court to intervene in the lower court's decision. Under the Indian legal system, jurisdiction to issue prerogative writs is given to the Supreme Court and High Courts of Judicature of all Indian states. Parts of the law relating to writs are outlined in the Constitution of India. Types of writs: habeas corpus, you may have the body; mandamus, we command; certiorari, to be certified; prohibition, stay order; quo warranto, by what warrants. The next page, sir.
एक मिनट.
Habeas corpus. Habeas corpus is a writ that is enforced to protect the fundamental right to liberty of an individual against unlawful detention. This writ commands a public official to deliver a detained person in front of the court and provide valid reasons for the detention. However, this writ cannot be issued in case the proceeding is for contempt of a legislature or a court.
देखिए, मैं इसको सरल भाषा में समझा देता हूँ. हैबियस कॉर्पस क्या होती है? आपने देखा होगा कई बार क्रिमिनल्स को पुलिस उठा करके ले जाती है, ठीक है, उनको मजिस्ट्रेट के सामने पेश नहीं करती. क्यों नहीं पेश करते? क्योंकि वो पहले उनसे पूछते हैं भाई क्राइम कैसे हुआ. उनका ऑफिशियल अरेस्ट नहीं दिखाते हैं, क्योंकि अगर ऑफिशियल अरेस्ट दिखा दिया तो विद इन 24 आवर्स आपको मजिस्ट्रेट के सामने पेश करना है. वो क्या करते हैं, 2-4 दिन उनकी वैसे पिटाई विटाई करते हैं और उनसे पूछते हैं भाई क्राइम कैसे किया. अब जिसके घर वाले परेशान हो जाते हैं कि भाई हमारे को पुलिस उठा के ले गई हमारे बच्चे को और वो नहीं कर रहे, तो वो क्या करते हैं, हैबियस कॉर्पस की पिटीशन फाइल करते हैं कोर्ट में. और फिर कोर्ट पुलिस को कहता है कि भाई देखो ऐसा है, कोई भी बंदा है या तो जिंदा या मुर्दा, उसको ला करके पेश करो कोर्ट के सामने, है ना. जिंदा है तो जिंदा लाओ, मुर्दा है तो मुर्दा लाओ. ये है हैबियस कॉर्पस, टू हैव द बॉडी. कि भाई उस पुलिस को कहती है कोर्ट कि भाई आप इसको ले करके आओ, हमारे सामने पेश करो. ये है कहानी हैबियस कॉर्पस की. ठीक है.
Certiorari. The writ of certiorari is issued to a lower court directing that the transfer of a case for review, usually to overrule the judgment of the lower court. The Supreme Court issues the writ of certiorari in case the decision passed by the lower court is challenged by the party. It is issued in case the higher court finds it a matter of over jurisdiction or lack of jurisdiction. It is one of the mechanisms by which the fundamental rights of the citizens are upheld.
देखो, सर्टी ऑरेरी नाम से ही पता चल रहा है. सर्टी मतलब सर्टेन, ऑरेरी मतलब हियरिंग. सो सर्टेनिटी ऑफ हियरिंग, बेसिकली द suppose the higher court finds that the lower court has exceeded its jurisdiction, so they will ask them to transfer the case to them for review. That is the basic purpose of certiorari.
Prohibition. Prohibition is a writ issued by a higher court to a lower court to enforce inactivity in the jurisdiction. It happens only in case the higher court is of the discretion that the case falls outside the jurisdiction of the lower court. Writ of prohibition can only be issued against judicial and quasi-judicial authorities.
Now what is this prohibition? Prohibition just उल्टा है. Prohibition में कहते हैं कि सब because various courts have got various powers. अब अगर हायर कोर्ट को लगता है कि भाई the lower court is exercising jurisdiction in a case where it is not competent, तो उनको बोलेगा कि भाई it does not fall within your jurisdiction, so you avoid hearing this thing, है ना. तो बेसिकली ये है, उसको बोलेगा लोअर कोर्ट को कि भाई आपको you need not exercise jurisdiction in this case because it falls outside your jurisdiction. ठीक है. जैसा सुप्रीम कोर्ट है, मान लीजिए एनसीएलटी है. अब एनसीएलटी जो है बेसिकली बहुत सारी चीजें वो नहीं डिसाइड कर सकता, मान लीजिए, है ना. तो फिर उस केस में क्या बोलेगा सुप्रीम कोर्ट के भाई देखो इट फॉल्स आउटसाइड. जैसे मान लो कॉन्स्टिट्यूशनल वैलिडिटी ऑफ आईबीसी, एनसीएलटी को राइट नहीं है ये सब करने का. वो क्या सुप्रीम कोर्ट कहेगा भाई मैं देखूंगा इस चीज. यस, मैंडामस.
Mandamus. The writ of mandamus is issued to a subordinate court, an officer of the government, or a corporation, or other institution commanding the performance of certain acts or duties. Unlike habeas corpus, mandamus cannot be issued against a private individual. The writ of mandamus can be used to order the completion of a task, or in other cases, it may require an activity to be seized.
मैंडामस में क्या है, मान लीजिए जैसे आजकल बुलडोजर वाली एक्टिविटीज चलती रहती है ना. कि भाई योगी जी ने यहाँ बुलडोजर चला दिया, वो चला दिया, तो सुप्रीम कोर्ट क्या बोलेगा, भाई देखो बुलडोजर मत चलाओ, ठीक है। तो इट मे रिक्वायर एन एक्टिविटी टू सीज। दूसरा क्या हो सकता है, सपोज कोई गड्ढा है, ठीक है, रोड पर गड्ढे हैं, तो अथॉरिटीज को बोल देगा भाई देखो इन गड्ढों को रिपेयर करो, एक्सीडेंट हो रहे हैं इस वजह से। तो ये रिट ऑफ मैंडामस, मैंडामस से मतलब मैंडेट से समझ लीजिए आप इसको,
Right, sir.
कि बेसिकली इट इज इश्यूड टू ए सबऑर्डिनेट कोर्ट ऑफिसर ऑफ द गवर्नमेंट और कॉर्पोरेशन और अदर इंस्टीट्यूशन कमांडिंग द परफॉर्मेंस ऑफ सर्टेन एक्ट्स और ड्यूटीज, ठीक है। तो
Yes.
दोनों चीजें होंगी, या तो कहेगा ये एक्टिविटी बंद करो, या बोलेगा ये एक्टिविटी करो, ठीक है। एक्टिविटी करने का मैंने एग्जांपल आपको बता दिया कि भाई रिपेयरिंग ऑफ रोड्स, है ना, ब्रिजेस
Yes, sir.
वगैरह। और सीजिंग ऑफ एक्टिविटी, जैसे कोई डिमोलिशन चल रहा है ना, वो सब उसको रोक सकते हैं, ये मेंटेनेंस।
Yes, sir.
यस।
Quo warranto. Quo warranto is issued against a person who claims or usurps a public office. Through this writ, the court inquires by what authority the person supports his or her claim. Through this writ, the court inquires into the legality of a claim of a person to a public office. This writ prevents the illegal assumption of a public office by an individual.
देखियो, इफ यू वांट टू होल्ड ए पब्लिक ऑफिस देन इट हैज टू बी लीगल, यू कैन नॉट इलीगली एज्यूम ए पब्लिक ऑफिस। तो ये इस केस में क्या करता है, फिर कोर्ट जो है को वारंटो की रिट इशू करता है।
Suspension of fundamental rights. Fundamental rights can be suspended in the case of national emergency, as mentioned under Article 352. The 6 fundamental rights under Article 19 are automatically suspended in the case of national emergency, is imposed on grounds of war or external aggression, which is stated under Article 358. Article 359 has the clause for suspension of other rights. In that case, a separate notification has to be issued by the President. The rights mentioned under Article 20 and 21 can never be suspended. Constitutional emergency, financial emergency cannot affect the fundamental rights.
देखिए, तीन तरह की इमरजेंसी है, एक तो है नेशनल इमरजेंसी,
Yes, sir.
एक है कॉन्स्टिट्यूशनल इमरजेंसी, और एक है फाइनेंशियल इमरजेंसी।
Supreme Court is the highest authority to uphold the Constitution of India, to protect rights and liberties of citizens, and to uphold the values of rule of law. Hence, it is known as the guardian of a constitution. The Supreme Court is the final court of appeal in all civil, criminal, and other matters, thus helps in maintaining a uniformity of the law throughout the territory of India. The constitutional jurisdiction of Supreme Court is stated in detail in Articles 124 to 147 of the Indian Constitution. Indian Constitution provides an independent judiciary with a hierarchical setup containing high courts and subordinate courts under it. There shall be a Supreme Court of India consisting of Chief Justice of India, and until Parliament by law prescribes a large number of not more than 7 other judges. The Supreme Court number of judges Amendment Act 2008 has raised it to 30 other judges. At present, the SC consists of CJI and 30 other judges. The National Judicial Appointments Commission consists of the following persons: Chief Justice of India, Chairperson, 2 senior-most Supreme Court judges, the Union Minister of Law and Justice, 2 eminent persons nominated by committee consisting of CJI, Prime Minister of India, and Leader of Opposition.
एक बार देख लेते हैं कौन सा इंपॉर्टेंट है, बाकी तो आप देख लीजिएगा, है ना।
राइट सर, कोई बात नहीं। The Supreme Court has
ये जो कोर्ट ऑफ रिकॉर्ड है ये इंपॉर्टेंट है।
yes,
तो
sir.
सुप्रीम कोर्ट एंड हाई कोर्ट दे आर कोर्ट ऑफ रिकॉर्ड। अब देखिए कोर्ट ऑफ रिकॉर्ड क्या होता है, कोर्ट ऑफ रिकॉर्ड में ये होता है कि एवरीथिंग इज रिकॉर्डेड,
yes, sir.
ठीक है। अब जैसे जो मेट्रोपॉलिटन कोर्ट्स होते हैं, लोक अदालत लगती है, वहां क्या होता है, वहां समरी प्रोसीजर होता है, वहां पूरा प्रोसेसिंग को रिकॉर्ड नहीं करते। तो कोर्ट ऑफ रिकॉर्ड कौन से है, सिर्फ हाई कोर्ट और सुप्रीम कोर्ट ही कोर्ट ऑफ रिकॉर्ड है, बाकी
Yes.
जो है वो कोर्ट ऑफ रिकॉर्ड नहीं है। एक ये पॉइंट देख लेते हैं कि ओरिजिनल जुरिस्डिक्शन कहां पर है और एपीलेट जुरिस्डिक्शन कहां पर है। तो कुछ ऐसे मैटर्स हैं, देर आर सर्टेन मैटर्स इन विच ओनली द सुप्रीम कोर्ट हैज गॉट द ओरिजिनल जुरिस्डिक्शन, उससे नीचे वाला कोर्ट उन मैटर को डिसाइड ही नहीं कर सकता।
Correct, sir.
है ना। हाँ जी, पढ़िए पढ़िए सर जी।
Yes, sir. The Supreme Court, sorry, sir. Yeah. The Supreme Court can take cognizance of a dispute involving any question, whether of law or fact, on which the existence or extent of a legal right depends. The apex court has exclusive original jury in dispute between the center and the state on one side and the state on the other side, 2 or more states. Case Union of India versus State of Rajasthan 1984, AIR 1675. Supreme Court pointed out that Article 131 is attracted only to those cases involving disputes between or amongst states and the union in the context of the constitutional relationship that exists between them and the powers, rights, duties, liabilities, immunities, etc. flowing therefrom. Exclusion of original jurisdiction. The Constitution excludes the jurisdiction under Article 131 in the following matters. Disputes arising out of any treaty, agreement, covenant, engagement, or other similar instrument which have been entered into or executed before the commencement of the Constitution, continues in operation after such commencement, or which provides that the said jurisdiction shall not extend to such a dispute. The Parliament may, under Article 262(2), exclude Supreme Court jurisdiction in adjudication of any dispute or complaint with respect to use, distribution, or control of the waters in any interstate river or river valley. Appellate jurisdiction.
Appellate jurisdiction.
Yes. The Supreme Court has jurisdiction over all the cases that come to it as an appeal against the judgments of the High Court only when it has the certificate of a case involving a substantial question of law as to the interpretation of the Constitution under Article 134A. Such a certificate shall be obtained only in the following situations. If an appeal lies only from any judgment, decree, or final order of the High Court, no appeal lies from an interim order. The case should delve with civil proceedings, criminal proceedings, and cases raising a substantial question of law as to the interpretation of the Constitution of the case. The question involved must be a substantial question, a question regarding which there is difference of opinion and which needs to be decided by the Supreme Court. So appeal by special
power to review.
Yes, sir. This is important, sir. Article 137 enables the Supreme Court to review its own judgments subject to provisions of any law made by Parliament. This power is exercisable under rules made by the court under Article 145, grounds of review. Review will lie in the Supreme Court on the following ground: discovery of new important matters of evidence, mistake or error on the face of the record, and any other sufficient reason.
तो अपने डिसीजन को भी रिव्यू कर सकता है सुप्रीम कोर्ट.
Yes, sir.
ये बहुत इंपॉर्टेंट है, आर्टिकल 142, and
Right.
it has been used in IBC also.
Right, sir. Power to do complete justice. Article 142 empowers the Supreme Court to pass any decree or judgment necessary for doing complete justice in any matter or cause. Any such decree passed by the Supreme Court shall be made enforceable throughout the territory of India in such manner as may be prescribed by or under any law made by Parliament, and until provision in that behalf is so made in such manner as the President may by order prescribe. Advisory jurisdiction. You pardon, sir?
पढ़िए.
Under Article 143(1), the Supreme Court has the jurisdiction to advise the President of India on matters referred to it for obtaining the apex court's decision. The scope of this jurisdiction is very wide, as the President can seek the opinion of the Supreme Court on any question of law or fact which appears to him to be of such a nature and public importance that it is expedient to obtain the court's opinion. Where such a reference is made, it has to be listened to by a bench of not less than 5 judges. The Supreme Court is not bound to give advice and may refuse to give its advisory opinion for strong reasons. The Indian
हमने पढ़ लिया पहले.
पढ़ लिया, sir. Yes. State judiciary.
ये आप देख लीजिएगा इसको, उसमें कोई खास बात नहीं है.
लेबर लॉस आ गया, sir.
हाँ, लेबर लॉस पढ़ लेते हैं.
The central government proposes to replace 29 existing labor laws with 4 codes. The objective is to simplify and modernize labor regulation. ये notify हो गया सर, ये 4 codes कर रहे थे.
अभी कहाँ हुए? नहीं हुए
ना सर, ठीक है. The President of 29 September 2020 assented to the 3 bills, namely the Industrial Relations Code 2020, the Social Security Code 2020, and the Occupational Safety, Health and Working Conditions Code 2020, passed by the Rajya Sabha on 23 September 2020, that concludes the government's codification of labor laws into 4 codes. The 3 bills were passed by the Lok Sabha on 22 September 2020, amalgamating and simplifying 29 labor acts. The first of the 4 codes proposed by the government, the Code on Wages, was passed by Parliament in 2019. However, the codes are yet to be implemented. मतलब notified, sir?
No, actually क्या है, अभी implement नहीं हुए ना, rules वगैरह तो आए नहीं है.
Yes, sir. तो यस सर,
ये
मिनिमम
इसमें ना
वेज।
एक काम करते हैं, हम सीधा अपना उस पर चलते हैं, पीएफ पर। ये वाला तो खत्म हो गया। चलो और आगे देखते हैं, पीएफ और ईएसआई, इसको कर लेते हैं जरा। पीएफ और ईएसआई के लिए मैं आपको अपनी साइट पर ले चलता हूँ। ये नजर आ रही होगी मेरी साइट आपको ना, है? इज इट विजिबल?
विजिबल सर।
है ना? हाँ। तो इसमें क्या है, आपको ये पीएफ एक्ट खोला हुआ मैंने, तो पीएफ एक्ट पहले ही देख लेते हैं एक बार, ये सेक्शंस 1 to 6। तो सबसे पहले तो इसमें ये देखते हैं। अभी तो क्या हो गया, ये स्टेट ऑफ जम्मू एंड कश्मीर पर भी एप्लीकेबल हो गया, वहां रंजीत कोड चलता था पहले, अब यही कोड वहां पर भी चलता है। अभी पहले सबसे पहला क्वेश्चन क्या है कि कितने होने चाहिए मिनिमम नंबर ऑफ वर्कर्स?
20 सर।
हाँ, बिल्कुल ठीक है। ठीक है ना? तो पहले क्या था, 20 और मोर पर्सन आर एम्प्लॉयड। ठीक। लेकिन ऐसा है, अगर लेस देन 20 पर अप्लाई कर सकती है क्या गवर्नमेंट? द आंसर इज यस। Central government may, after giving not less than 2 months notice of its intention so to do, by notification in the official gazette, apply the provisions of this act to any establishment employing such a number of persons less than 20 as may be specified in the notification. ठीक है? तो गवर्नमेंट के पास पावर है। चलिए नेक्स्ट पेज पढ़ते हैं। तो पहली बात तो क्या ध्यान में रखनी है, 20। ये हो ही गया। एक मिनट, उसके बाद में हम चलते हैं डेफिनेशंस पर। डेफिनेशन में क्या है, एक तो बेसिक वेजेस की डेफिनेशन है। बेसिक वेजेस क्या है? बेसिक वेजेस मींस ऑल एमोलुमेंट्स व्हिच आर अर्नड बाय एन एम्प्लॉय व्हाइल ऑन ड्यूटी और ऑन लीव और ऑन हॉलिडे विद वेजेस इन आइदर केस। ठीक है? बट इट डज नॉट इंक्लूड, क्या इंक्लूड नहीं है बेसिक वेज में? क्या इंक्लूड नहीं है जी, पढ़ना जरा।
यस सर, does not include cash value of any food concession,
हम्म।
any DNS allowance, that is to say, all cash payments by whatever name called paid to an employee on account of a rise in the cost of living, house rent allowance, overtime allowance, bonus, commission, or any other similar allowance payable to the employee in respect of his employment or of work done in such employment, any presents made by the employer.
हम्म।
So these are exempted, sir. Contributions means
एम्प्लॉयर की डेफिनेशन पढ़ लेते हैं पॉइंट ई में।
employer means in relation to an establishment which is a factory, the owner or occupier of the factory, including the agent of such owner or occupier, the legal representative of a deceased owner or occupier, and where a person has been named as the manager of the factory under clause F of subsection 1 of section 7 of the Factories Act 1948, 63 of 1940, the person so named, and in relation to any other establishment, the person who or the authority which has been ultimate control over the affairs of the establishment and where the said affairs are entrusted to a manager, managing director or managing agent, such manager, managing director or managing agent.
एम्प्लॉय का भी डेफिनेशन पढ़ लेते हैं।
Right, sir. Employee means any person who is employed for wages in any kind of work, manual or otherwise, in or in connection with the work of an establishment, and who gets his wages directly or indirectly from the employer, and includes any person employed by or through a contractor or in connection with the work of the establishment, engaged as an apprentice, not being an apprentice, engaged under the Apprentices Act or under the standing orders of the establishment. Exempted employee means an employee to whom a scheme or insurance scheme, as the case may be, would, but for the exemption granted under Section 17 have applied. Exempted means,
एक बार फैक्ट्री का मतलब पढ़ लेते हैं.
yes, sir. Factory means any premises, including the presence thereof in any part of which a manufacturing process is being carried on or is ordinarily so carried on, whether with the aid of power or without the aid of power.
तो इतना तो कम से कम हमें मालूम होना ही चाहिए.
इसमें ये क्वेश्चन जरूर आता सर.
हाँ, एक क्वेश्चन तो आ ही जाए.
पीएफ में, टोटल पीएफ में वन क्वेश्चन जरूर आता.
एक बार स्कीम पढ़ लेते हैं.
चले रीड इट सर.
नहीं, एक मिनट, उसकी जरूरत नहीं पड़ेगी आपको. ये कंट्रीब्यूशंस.
यस सर. या ये पढ़ो सर.
हम्म.
Contributions and matters which may be provided for in scheme. The contribution which shall be paid by the employer to the fund shall be 10% of the basic wages, DNS allowance and retaining allowance, if any, for the time being payable to each of the employees, whether employed by him directly or by or through a contractor, and the employee's contribution shall be equal to the contribution payable to the employer in respect of him and may, if any employee so desires, be an amount exceeding 10% of his basic wages, DNS allowance, and retaining allowance, if any, subject to the condition that the employer shall not
अभी
be.
हो गया 12%, है ना?
So
तो 12%
10%.
हो गया. लिखता है ना, वेयर एवर द वर्ड्स अकर, द वर्ड्स 12% शैल बी सब्स्टिट्यूटेड.
12% कर दिया ना सर. 7 वाला सर.
एम्प्लॉयज पेंशन स्कीम, एम्प्लॉयज डिपॉजिटिंग, लेइंग ऑफ स्कीम्स बिफोर पार्लियामेंट. एक एम्प्लॉयज डिपॉजिट, भाई इतना कोई जरूरत नहीं है, मेरे ख्याल से काफी है.
हाँ.
एक तो नंबर ऑफ एम्प्लॉयज पे पूछ लेता है, इसमें कितने होने चाहिए वो आपको मालूम ही है. ईएसआई में 10 है, यहाँ पर 20 है. ठीक है. उसके अलावा
तो ये 10 इंक्रीज कर दिया सर, 12 इंक्रीज कर दिया क्या?
12% है वो. नंबर
हाँ.
ऑफ एम्प्लॉयज की बात कर रहा हूं मैं. नंबर
नंबर
ऑफ
ऑफ
एम्प्लॉयज
एम्प्लॉइज
ईएसआई
20.
में 10 है और पीएफ में 20 है.
शेयर ऑफ कंट्रीब्यूशन 10 12 हो गया सर.
हाँ.
हाँ.
चलिए अब जनरल अवेयरनेस में ये तो हमने देख ही लिया. ये मैं थोड़ा सा शेयर करता हूँ आपसे. ये ये जनरल अवेयरनेस वाला पीपीटी मेरे ख्याल शेयर किया हुआ आपसे ना, ऑलरेडी किया हुआ ना ये. दिस आई ऑलरेडी शेयर्ड आई थिंक.
Yes, sir.
है ना? तो इसमें क्या है कि आपको ना थोड़ा सा ये ध्यान में रखना है कि भाई नाम तो पता होने चाहिए आपको. ये राइट्स हमारे क्या हैं. हाँ जी, पढ़िए एक बार जरा सुधाकर जी.
राइट सर.
हम्म.
Rights. The fundamental rights are enshrined in Part 3 of the Constitution of India, 1950. There are broadly 6 categories of fundamental rights, and they are as follows: right to equality, Article 14 to 18; right to freedom, Article 19 to 22; right against exploitation, 23 and 24; right to freedom of religion, 25 to 28; cultural and educational right, 29 and 30; right to constitutional remedies, Article 32. So there was one more fundamental right to the Constitution of India, right to property, which was removed by so and so, so and so. Some of these rights are available only to the citizens of India, while some are available to non-citizens also. Fundamental rights available to all persons, including non-citizens. Right, equality before law and equal protection of laws, Article 14. Article 14 ensures that the state shall not deny to any person equality before the law or the equal protection of the laws within the territory of India. This provision applies to both citizens and non-citizens, guaranteeing non-discriminatory treatment. Protection in respect of conviction of offence, Article 20. Article 20 provides protection against ex post facto loss, double jeopardy, and self-incrimination. These protections are available to all individuals regardless of citizenship. Protection of life and personal liberty, Article 21. Article 21 is one of the most significant rights under the Indian Constitution, stating that no person shall be deprived of their life or personal liberty except according to the procedure established by law. This right is available to all persons, including non-citizens. Right to elementary education, Article 21A. Article 21A inserted by the Constitution, 86th Amendment Act of 2002. The primary objective behind this article is to provide free and compulsory education for all children in the age group of 6 to 14 years. Protection against arrest and detention in certain cases, Article 22. Article 22 provides safeguards against arbitrary arrest detention, ensuring that individuals have the right to be informed of their grounds of their arrest and the right to legal representation. This applies to all people, including non-citizens. Prohibition of traffic and human beings and forced labor, 23. Article 23 prohibits the
आज
trafficking
एक
of.
बार ये पढ़ लीजिएगा, ठीक है।
ठीक है सर, या
ये सारे हमने आर्टिकल इसमें दे रखे। आर्टिकल 19 में क्या है? आर्टिकल 19 एक बार खास तौर से पढ़ लीजिए, क्योंकि बहुत बार रेफरेंस है इवन इन आईबीसी।
Right, sir. Protection of certain rights regarding freedom of speech, etc. Article 19. Article 19 guarantees 6 rights which are exclusively available to citizens, including right of speech and expression, to assemble peaceably and without arms, to form association or unions, to move freely throughout the territory of India, to reside and settle in any part of the territory of India, to practice any profession, to carry on any occupation, trade or business. So, yeah.
तो ये हो गया राइट्स ऑफ वर्कमैन, ये तो हो ही गया, हमने कर ही दिया, है ना। ये इकोनॉमी के ऊपर है, थोड़ा बहुत आप देख लीजिएगा इसको, फाइनेंशियल मार्केट्स। ये उसका है फ्रॉड के बारे में। ये बहुत सारी टर्म्स हैं फिर इसमें, जो फाइनेंशियल उसमें पूछ लेते हैं आपसे। ये कुछ क्वेश्चंस हैं, दिस यू कैन गो थ्रू, है ना। इनके आंसर भी दे रखे हैं हमने बाद में, तो इसको एक बार पढ़ लीजिएगा तो थोड़ा सा आइडिया आपको हो जाएगा। और फिर मैंने क्या किया, आपको एक ऑनलाइन टेस्ट भी दिया है ना।
Yes, sir.
तो ऑनलाइन टेस्ट भी दिया है, उसको भी एक बार देख लीजिएगा। आज की कथा यहीं समाप्त करते हैं,
ठीक है सर।
है ना।